Senator from Louisiana.
Mr. President, I rise to urge my colleagues to support House Joint Resolution 83 and its Senate companion, SJ Res 27, a resolution I introduced along with 25 of my colleagues under the Congressional Review Act, also known as the CRA, to stop the Obama administration Department of Labor's regulation known as the Volks Rule from expanding the statute of limitations for record-keeping violations. This regulatory scheme represents a backwards approach to workplace safety and is a blatant overreach by the federal government. Under the Occupational Safety and Health Act, employers are required to record injuries and illnesses that occur in the workplace and maintain those records for 5 years. The law provides for a 6-month period for which OSHA can issue citations to employers who fail to maintain the records properly. However, it was the practice of OSHA, based on their interpretation of the law, that they were able to issue citations regarding keeping these records properly for the entire 5-year period. Employers must keep those records. Under this practice, OSHA took action against Volks Constructors, a firm in Prairieville, Louisiana, in 2006 for record-keeping violations that occurred nearly 5 years earlier. Again, record-keeping violations. This was well beyond the 6-month statute of limitations. Volks Constructors, again located in Prairieville, is a heavy industrial contractor that provides manufacturing services and industrial specialties to the petrochemical and related industries. It has been in business for more than 40 years. Volks challenged OSHA in the D.C. Circuit Court of Appeals for those citations and won. The Circuit Court of Appeals issued by a unanimous 3-judge opinion rebuking OSHA's attempt to file citations past the statute of limitations. One of the 3 judges was President Obama's Supreme Court nominee, Judge Merrick Garland. The Volks ruling has since been upheld by the 5th Circuit Court of Appeals. Let me read a few of the comments from the court's opinion. We do not believe Congress expressly established a statute of limitations only to implicitly encourage the Secretary to ignore it. Another comment. The Act clearly renders the citations untimely, and the Secretary's arguments to the contrary relies upon an interpretation that is neither natural nor consistent with our precedents. And from Judge Garland's concurring opinion, because none of the challenge citations were issued within 6 months, quote, following the occurrence of any violation, I agree with my colleagues that the petition for review should be granted and the citations vacated, end quote. After the court was clear in its ruling, OSHA, in order to negate such ruling and continue issuing citations beyond the 6-month statute of limitations, promulgated this regulation, the Volks Rule. This joint resolution must invalidate the Volks Rule. The Volks Rule is a clear violation of the court's ruling and is in direct contradiction of the 6-month statute of limitations. Only Congress can amend a federal statute. Article 1 of the U.S. Constitution is clear. Members of the legislative branch write the laws, not the federal departments and agencies. Overturning the Volks Rule will not decrease workplace safety. The rule only changes the window during which OSHA can issue citations for record-keeping violations. This rule is about paperwork violations and not workers' health or safety. The Volks Rule also creates regulatory confusion for small businesses. By finalizing this unlawful regulation, the Obama administration created uncertainty for employers facing a confusing maze of record-keeping standards and unwarranted litigation. The U.S. Chamber of Commerce, the Association of General Contractors, the National Home Builders Association, the National Restaurant Association, the National Retail Association, along with more than 70 state and national organizations, all support this joint resolution. Mr. President, I ask unanimous consent to insert the Coalition for Workplace Safety's letter for the record.
Without objection.
I urge my colleagues to support this joint resolution and allow Congress to review the law and make changes if needed. It is the right thing to do. Mr. President.